Yeah, I think we're open to questions, which can be asked via the chat box. Maybe we'll start with the first question. What about digital-based medical devices? How do you show infringement of a patent relating to a digital-based medical device? Could you answer that for Israel, Asa?
Yes, okay, I'll start off with that. I think that's a pertinent question to this crowd, I assume. And there are certain specific issues that should be taken into account when considering digital health products, which are actually largely data-driven. So where we speak about inventions or patent-protected inventions which relate to data sets and problem solving using such data sets, one needs to be when examining whether a competitor is infringing, one needs to understand that merely solving the same problem would not be determined as an infringement. That is not enough to constitute, in most cases, infringement, at least in Israel, of a patent. One needs to identify that the same solution, as is described in the patent, is indeed used by the alleged infringer. And how do you do that in the big data space? That is a challenge. And actually, when interpreting patents, big data patents, I believe that in many jurisdictions, the courts have not stated how such patents should be interpreted. And in accordance with the actually Israeli Patent Office procedures or comments made, merely comparing data sets that might be used or presented in patent applications might not be enough to show infringement. One would need to show both use of similar data sets and of course, using other elements of the invention. Then the question arises when we speak about data sets per se, that they'll be mostly protected by copyright, and that already makes the picture more convoluted. So those are two issues that might need to be addressed when thinking of, is this a competitor that is actually infringing my rights, at least in Israel? How would be the situation in Europe in that regard, you think?
It's a good question. I think there are many issues that could potentially arise and would need to be addressed in court cases. There could be evidence issues. So maybe Stella, you can say something about the situation in the UK.
Sure. So in the UK, we have disclosure, which is helpful. There is initial disclosure that's required with the pleadings, and then there's the opportunity for extended disclosure within the course of those proceedings, and the infringer will have to provide some form of disclosure. It may be the result of a search, or the infringer can opt to provide a technical document such as the product or process description, which must deal with the issues in the claim. Sometimes we'll use inferences. So, for example, when we're pleading out the infringement case, if the device has to comply with a certain code, it might be inferred that at least some aspects of the claim are infringed, because in order to be on the market, it has to comply with that code, and some of the requirements of the code are parts of the claim. In terms of any jurisdictional issues, so for example, if a processing step is occurring abroad, there was a case a few years ago involving maternal blood sampling for fetal anomalies, and the actual processing was taking place abroad, And in that case, the court said, well, where is the substance of the infringing process taking place? And on the facts of that case, the court held that it was indeed in the UK, and so there was infringement. So that's, it is a challenge, but that's how we deal with some of the aspects relating to digital-based devices in the UK.
Thanks, Stella. Like a similar decision in the Netherlands about where does a process take place in substance, I don't think that exists. But as we explained earlier during the presentation, courts in Europe, they really look at each other, especially the Dutch, German, and the UK courts, about developments there. So if a situation like that arises in the Netherlands, we would certainly refer to the UK case, which we think then likely the Dutch judge would also follow. I think what we're discussing now nicely ties into the question about, which is just asked, about the type of evidence that is collected for an infringement suit. I think you addressed that nicely for the UK, Stella. Miriam, maybe you can indicate if there are differences in Germany. What type of evidence are you looking for?
Yes, of course. So, I mean, there are several types of evidence in general, such as, for example, expert declarations. These are often used for technical questions. The court needs to understand how the product actually works, whether a solution is really embedded in an infringed embodiment. So for this type of question, expert evidence is usually used. You could also imagine to have witnesses, for example, also showing how a process works or explaining how it works, or whether a specific process was already used before a specific date in a company. If you were to rely on a prior use right, that would usually be evidenced by witnesses. Then you could also think about evidence on distribution channels or the amount of product that is necessary. So in preliminary injunction proceedings, German courts would look at written evidence or readily available evidence. That is how they call that, because they really need to take a quick decision. So there have to be written declarations, affidavits, and expert evidence. Whereas in proceedings on the merits, you would hear an expert in court, and you would also hear witnesses rather than just reading their affidavits, because the courts want to see it. We also briefly discussed seizures. You can, for example, a raid may be an option to when you need to look at a big machine, for example, for tablet manufacturing or something like that. Then you can really go to the premises and look at it. Or you can also seize plans, structures about the specific devices, or material from the authorization process. So where specific things are explained that cannot necessarily be found when you just look at the device or try to dismantle it and see how it works. So some things only the infringer has knowledge about, and there are certain ways to get that knowledge or that material from the infringer as well.
Thanks, Miriam.
Does that answer the question? I hope so.
I think it does. The situation for the Netherlands is pretty much similar to Germany. In the Netherlands, the court accepts all kinds of evidence that can be a printed web page or expert evidence, witness evidence, the product itself, anything really. We also have the possibility of doing a raid at the premises of the infringer or a third party. In the Netherlands, the court is quite lenient in allowing you to do such a seizure. And the court will also allow you to do that seizure for the purpose of an infringement proceeding abroad. Mm-hmm. So you could seize evidence in the Netherlands and then use that somewhere else as well if you want to bring proceedings in another country.
If I may about that to Israel.
Yes, please also explain for Israel how it works, what type of evidence.
Yes. Yes, actually, the situation is quite similar to the ones that you just described in Germany and Holland. Although for preliminary stages, we call the evidence you have to make a prima facie case, not a full case on the merits, as Miriam called it. We don't need our equivalent to the readily available evidence would be making evidence enough to make a prima facie case, a case on its face that seems to show infringement. I think it's even a lower, supposed to be a lower standard. That's by the letter of the law, but by way of practice, actually, courts are very careful in issuing preliminary injunctions in novel, innovative areas, because in many cases, actually, they don't understand enough technology-wise. And we see that the courts in some cases nominate assessors. They have in the Israeli patent law, there's a possibility to nominate that the judge may nominate a technological assessor to assist the judge in evaluating the case. That provision was made actually to support the case, the case on the merits. But we see that also in preliminary injunctions, judges sometimes opt to nominate such an assessor where the technology is not readily understandable. And that might be the case in the digital health space, where it is not always straightforwardly understood what is the actual innovation or what actually constitutes the infringement. And just to touch the last note of the possibility of raids, of course, that is also available in Israel, certain parallel to the UK Anton Piller historic order. But there, again, in the digital space area, the courts are very wary in issuing seizure orders of databases of computers, which is technologically challenging, and the boundaries also need to be strictly defined, and those are very difficult to set out.
All right, thanks, Asa. Maybe a next topic to discuss is how it works with clinical trials. Are they exempted under patent law, or can you still infringe a patent also when doing a clinical trial? Maybe we can start in the UK.
Sure, thanks, Ruud. So the short answer is there are a couple of defences available. They're unlikely to help a medical device company in their clinical trials. We have an experimental use exception. However, that is interpreted quite narrowly, and it must be genuine. The tests must be genuinely to discover something new, a new hypothesis. So if those tests are for something else, so for example, you are allowing doctors in a hospital to try out some stents to give them confidence, or it's for regulatory approval, then those tests you will not be able to use the experimental use defense to help you. We also have a BOLAR type exemption, but that is for clinical trials really limited to medicinal products and generics. So the answer in the UK is unlikely to help you. Available, but unlikely to help.
Okay. In other countries, how does it work? Miriam, can you say something about Germany?
Yeah, maybe one general point. I mean, there is the experimental use exemption, but you have to be very careful because there is a very important distinction on any research on the invention or research with the invention. So if you only use the invention to discover something else, or is it where it's a process to discover new antibodies or whatever you think of, then this is research using the invention and not finding out more about the protected invention. And in that case, you don't benefit from the experimental use exemption. So that's one very important thing to keep in mind. But otherwise, yeah, the exemption is available.
I always like how you explain that, Miriam. What you explained for Germany basically also applies in the Netherlands. So the distinction between research on or research with the invention. In the Netherlands, it's a quite strict exception, and in most cases, it is not met, especially if there's a commercial or a marketing purpose, then it will be considered an infringement. How does it work in Israel, Asa?
Well, we'll have a similar system in place. Experimental use exemption is similar to what you, Ruud, and Miriam explained, that the exemption is for the actual use of the invention. There's not much case law in that regard. We enjoy also a BOLA exemption. As Stella noted, the BOLA exemption is unique to pharmaceuticals and not necessarily to medical devices. There's a certain discrepancy there because when the counterbalance to the BOLA exemption is the patent term extension in the patent law, and actually patent term extension can be granted for medical equipment in addition to pharmaceuticals. Although I don't know of a case that a patent term extension was granted to medical equipment up until now, but with the growth of activity in the medical device space, we might be seeing that in coming years, especially in view of certain amendments to the 2012 Israeli medical equipment law, which addresses regulative aspects of of the field, as well as regulations that were made but were not as yet enacted, or have not as yet come into force. So it's a changing field in that regard, and I feel that the Israeli legislator understands that there's a need to give a high degree of freedom for players in the field of medical devices, and especially in connection with the digital health aspects. So we'll see how that evolves.
All right. Perhaps still time for a final question. How does it work with the current pandemic? Are we still doing litigation? Is there still litigation going on in Israel? Can you do a virtual trial?
Yes and no. During the first lockdown, so the practice of virtual trials in urgent matters was really practiced, using actually even such means. But quite quickly, most judges, once the first lockdown was alleviated, so most judges enabled their hearings in court under certain restrictions of amount of people in the room, in chambers, and we're actually almost back to regular practice by way of courts. And also at the patent office, just a fortnight ago, they stopped holding virtual hearings. And again, back to normal up to the next lockdown, which we hope will not.
Right. I think in Europe it's a bit mixed at the moment. So in the Netherlands, we can do virtual hearings. Basically, the courts decide whether they want to have the hearing virtually or digitally. I have a hearing in person next week, but earlier in the year I had some hearings virtually. At the EPO especially, it's mixed. In opposition proceedings, we see that if parties object to a virtual hearing, then it might very well be that the hearing will be postponed until a later time. But I think most court hearings are continuing. Perhaps Stella or Miriam, you can add how that works. Is it ongoing?
Yeah,
it's
so,
pretty much,
sorry, Stella, you go.
I was going to say, in the UK, it's pretty much business as usual. It's largely remote via Skype or Microsoft Teams. We even can do cross-examination. We've done transatlantic cross-examination during trial remotely. There is also the possibility of going to court, but that is rare.
Right, Miriam?
Yeah, so for us, even within Germany, it's mixed. It really depends on the specific court or the parties. And as you said, just as with the EPO, you can object to a virtual hearing, and then sometimes also parties use that to try to get the hearing postponed altogether, especially if you fear that you won't have a favorable decision. That may be an option that you might use. Yeah, so it's happening, it's available, but it's really every court, every judge does it slightly differently.
Right, but I think the good message to right holders is that you can still enforce rights in Europe or in Israel.
Yeah.
Let's see. I think we are at the end of the session. So I think that leaves us with us thanking everybody in the audience for participating and for questions and listening to our talk. And if anyone has any questions to us, I think you have our address details, our contact details. So please feel free to reach out.
Thank you very much. It was a pleasure.
Thank you. Have a very nice rest of your day. Enjoy the conference.